Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about privacy in condominium buildings. Cases that should have gone to the Supreme Court of Canada, but didn't. Ken Ying Mai was convicted of a number of drug trafficking offenses. The evidence that was led in the case to prove that he was involved in the drug trafficking operation included a large amount of surveillance from the elevators, hallways, and floors of his condo building. Essentially, anywhere that there was a common area in any of the condo buildings that Mr. Mai frequented, the police would enter, obtain permission from the property manager to install cameras, and use those cameras to generate surveillance of the individuals. They relied on the permission from the property manager as the basis to get the authorization to enter the buildings, skipping the requirement that they get a warrant to conduct this surveillance. If the police had been doing something similar at a private house, that conduct would have been considered to be unlawful. The only difference in the case was that the conduct took place in a condo building, which raised the important question for the Supreme Court of Canada: do people who live in condos have fewer privacy rights than people who live in houses? Certainly that can't be the law in Canada. If you think about it, in Canada, to have a house versus to have a condo or to rent an apartment means you have more financial resources. People who own homes are generally better off than people who live in apartments and who lived in condominiums. And so, in the circumstances, aren't people who are living in poverty, people who are poor, being given fewer rights to privacy than people who have more resources to buy themselves a house with a nice big fence to protect themselves from the public? Isn't your condo tower's walls supposed to serve as a fence against the public and prevent access to the police? And how can your building manager waive your privacy rights for you? This case doesn't even square with previous decisions from the Supreme Court of Canada that say that if the homeowner lets you into the house and then gives you her husband's laptop to search, that's a violation of your privacy rights, even if the two people are living in the same house and even if access to the laptop is shared between the two of them. If that's not a violation, if that is a violation, then how is being in a condo building and getting permission from the building manager, who may not even live there, permissible? The Supreme Court of Canada obviously had a significant question here about rights, about poverty, about people who have fewer resources than other people, and about applying the Charter in a fair and sensible way that confers the same rights to all individuals regardless of their economic circumstances, which is something that is in fact guaranteed by the Charter. And yet the Supreme Court of Canada missed this opportunity to do more, to address an issue that ultimately is the result of systemic discrimination against people who have fewer financial resources and the over-policing of communities involving people who have fewer financial resources. And the Supreme Court of Canada missed this opportunity to see how these Charter issues are engaged in these cases and to make a decision that made sense for people who are living in these circumstances and who don't have a choice but to get out of them. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.